Hi everyone, and welcome to In Solidarity, the podcast run by openDemocracy. My name's Sian Norris, and I'm a senior investigations reporter on the UK team. And I'm joined today by Katy Watts, a lawyer with the human rights campaigning group Liberty, who recently defeated an attempt by the UK government to appeal a High Court ruling that found clauses relating to protest and serious disruption in the Public Order Act 2023 were unlawful. Now, some of you may have been listening to me recently on the podcast talking about the Public Order Act and protest and the impact of the anti-protest laws on our civil liberties. Since publishing, a number of climate activists have received long prison sentences under the new powers. Indigo Rumbelow received 30 months, Leonora Ward received 18 months, Margaret Reed received 18 months, and Daniel Noor received 24 months. All of them were part of the Just Stop Oil movement, and the sentences were related to an action plan against Manchester Airport. Now, when this news broke, we knew we had to respond to it, and that's why we invited Katy to come and talk to us today about the impact of the anti-protest laws and what these sentences mean. So Katy, what was your reaction when you heard about these sentences, and more broadly, to the sort of long sentences that we are seeing being given to protesters under the new powers?
Thanks, Sian. I think it's obviously really concerning, but not or no longer surprising to see these kinds of really disproportionately long sentences imposed on activists for taking part in or even for just planning protests and actions. I'm sure people will also be aware of the really long sentences that were imposed last year on some Just Stop Oil activists for conspiracy to protest, to carry out protest actions. And I think it's, I suppose, particularly dispiriting to see these new sentences because the ones last year were challenged in court, and there wasn't a court of appeal ruling that in sentencing judges should take into account the fact that in protest cases, these are acts of conscience and people's human rights, the right to protest, the right to free expression should be taken into account when considering the length of sentences. So as I say, it's particularly dispiriting to see that actually not much has changed, that we're still seeing really long sentences. But I think that actually just reflects more than anything the kind of state of protest law in this country, the vast changes that have happened over the last 4 or 5 years in terms of new police powers, new criminal offences. And that has gone hand in hand, I think, with an increasingly hostile climate to protesters, both from the government, obviously, but increasingly also within the courts in terms of kind of case management decisions and, as we've seen, sentencing, which has led to just a very, very hostile environment altogether for the right to protest.
Absolutely. And I think that's really interesting what you say about the courts, because a lot of the people I interviewed when I was doing this investigation sort of raised that, and that point of the right of conscience, the right to kind of, have that as a defense, or not even sort of being considered in a way that you would think, actually, that's what we have. That's how human rights work in this country. You are allowed to use these defenses, and yet they just weren't being taken seriously. I mean, what kind of effect do sentences like these have on people's broader sense about protest? Are we seeing a chilling effect? Do people feel that it's not something they are able to do because, they're scared of going to jail? Or has it in other ways emboldened protesters because they're like, well, we're going to get into trouble, so we might as well go full pelt?
I mean, I think probably both. So I think it's definitely true that this has created a chilling effect for protest rights. I mean, and we've seen that with Just Stop Oil, who've recently announced that they are going to be ceasing to carry out direct action. And there are many reasons for that, that are not simply a response to the increasingly hostile environment for protest, in terms of the goals that they were seeking to achieve when they set out. But I think it is absolutely also true that increased police powers, new criminal offences, and these really long prison sentences, of course, have made it much more difficult for people to take part in the kinds of protests that a few years ago would not have led to a prison sentence. But in terms of emboldening people, I think the other thing that we've seen again over the last few years is that these the new offences particularly are targeting the kinds of direct action tactics that protest groups have come up with. And so what we see is a sort of cycle of the criminalization of certain kinds of tactics leading to ever more kind of creative responses to that, and the need to kind of come up with new kinds of protest tactics in order to get around the new offences. I think that's one of the most sort of dispiriting things about all of this, is that the government's response to protest movements is just to try and outlaw the tactics that they're using, rather than to think about tackling the issues which are at the heart of those protests.
That's really interesting. And I mean, just thinking about some of the tactics that have been developed, one of the big changes that came in the Public Order Act was the locking on offence. And I think a lot of people had concerns that, not only would that criminalise the people who were in the locking on protest, but also the preparation for locking on, which could sweep in all sorts of people who might just be minding their own business. I mean, when I was doing my research, I didn't find any cases where, someone had been carrying a bike lock and then ended up arrested. But is that a concern, that the broader we go, the wider we make these offences, the more I hesitate to use the word innocent, because people are innocent until proven guilty, but also I don't think protesters should be seen as guilty. But, sort of bystanders, maybe that's the better word to use, like bystanders getting caught up in this.
Yeah, I mean, the best example of the being equipped to lock on offence being used in a totally misguided way was the arrest of the Republic protesters at the coronation, where they had arrived at the protest. They had used cable ties to secure the placards they were planning to wave, and they were arrested for being equipped to lock on, because those cable ties could also have been used to lock on, which is an offence of attaching yourself to another person, or to a building, or to an object, or an object to another object. And so that's obviously ludicrous. I'm not aware. There have been cases of protesters. I think there was a case of some animal rights protesters who were certainly arrested for being equipped to lock on. But I'm not aware of lots of examples at the moment. But I think the worry with all of this stuff is that once you give the police these powers, then they're on the statute book, and the police can use them. Those locking on powers, which were included in the Public Order Act, that act also included new powers of stop and search in relation to protest, including suspicionless stop and search. So again, you can see how that could be used hand in hand. There's a protest going on, you can stop and search people who are attending that protest without even suspicion. You can potentially find all manner of things that could potentially be used to lock on. It could be a bike lock. It could just be, the fact that you're wearing a belt, or that you've got like laces in your shoes. And, if there is a protest that, the government at the time, or the police particularly, want to crack down on, they now have this huge swathe of new powers to do that. So whether or not they're being used immediately following the bill being brought into force doesn't, I think it's still concerning that these powers exist, and there's definitely the potential for them to be used in a really sort of concerning way in the future.
Absolutely. And I think this is something I've said for a long time about all sorts of different crackdowns on civil liberties is, I mean, we can criticize both governments that we've had recently, but, we are in a democracy, we are in a, we have a democratic system, but nobody knows what's around the corner. Like, authoritarian governments can come in very quickly. And if these laws are in place, they might be used sort of on a smaller scale now, but there is that chance when they're on the statute books to cause so much more harm, because a malign force or a malicious government wants to use them to cause harm. And I'm saying that in the full knowledge that they're already, bad laws that are causing a lot of harm. But that sort of sense of like, we live in this democracy and everything should be fine is not something we can always be secure in, because bad things happen.
I think that's one of the concerning things, is that there's all of this new anti-protest legislation, and it's also going hand in hand with, as I've said, the kind of creeping use of surveillance, the rollout of facial recognition technology. And when all of these things go hand in hand, you've kind of got a ready-made framework, as you say, for government or other kind of force in the future to really use it in a way which is kind of even more malevolent than we're seeing today.
So I wanted to go back to, when the PCSE and the Public Order Act, the Police Crimes and Sentencing Act and the Public Order Act were introduced. Like, what do you think was the sort of driving force for the government at the time to kind of clamp down on protests? Like, what were the the drivers of this ambition?
I think it was pretty explicitly a response to the rise of environmental protest movements, particularly Extinction Rebellion, um, and the Black Lives Matter movement in 2020. So what we saw was the kind of mass protests on the streets of London in April 2019 from XR, which really shut down quite a lot of central London, and a really strong police response to that. Then obviously during the COVID pandemic, in response to the murder of George Floyd, people took to the streets of London. And I think, it was quite clear that the government were bringing in these laws in response to those two things. Priti Patel said as much at the time when she was the Home Secretary in January 2021 when the Police Crime Sentencing Courts Bill was published. And she said, this is necessary to deal with these new protest movements. So it was explicitly a response to that. And what we then saw was the PCSC bill, which contained lots of new police powers to limit and control protests, and some new offences and some increased sentences for other kinds of offences. And then almost as soon as that passed through Parliament, they immediately, and by this point it was Suella Braverman, immediately put in, a further act, which was sort of slightly different. That was primarily concerned with creating these new offences under the Public Order Bill. And so, as I say, I think it was, a response to protest movements. And then as those protest movements responded, there were huge protests against the PCSC bill, the Kill the Bill protests. And so, as soon as the government saw that response, saw new kinds of tactics, which were then targeted with criminal offences of tunnelling and locking on. So, the government, I think, was quite clearly trying to crack down on some very some specific protest movements.
And I want to go back to the specificity of the targets, but also it seems like a good time to ask you about the legal challenge you launched on the Public Order Act and the fact that it came so soon after the PCSC that there was almost no time to catch up with what had just been passed. And then suddenly all these new offences were coming in, ones that they couldn't get past before and were just determined to get through the legislature. Can you talk us through your legal challenge and then the appeal that followed?
Yes, I can try without making it too technical, because there was quite a complicated legislative background. But essentially, when the Police Crime Sentencing and Courts Act was going through Parliament, they included a clause which would give the Home Secretary a power at a later point to define or to clarify the meaning of serious disruption, which is the sort of threshold used by the police in order to impose limits, controls, conditions, on protests and sometimes shut them down. And we spotted that at the time, and we thought, well, this is quite a broad power that you aren't defining it now, but you're just giving yourself the power to do it later. We should probably keep an eye on that. Anyway, fast forward not very long, that bill became an act, and then, as I say, almost immediately was followed by the Public Order Bill, creating a whole range of new offences. And during the passage of that bill, the government decided to shoehorn in an amendment which would have defined serious disruption as any more than minor impact on the local community. So any kind of more than minor impact which might be expected from a protest would then allow the police to kind of interfere. And the Lords didn't like the amendment. They argued that they hadn't had enough time to debate it, and so it was voted out of the bill and kind of died a death. Within weeks, I think before the actual act had even got royal assent, they then went back and used the power that they'd given themselves in the earlier bill to make that change anyway, which we, as far as we're aware, is the first time the government has ever tried to do something by primary legislation, failed, and then done it anyway by secondary legislation. And secondary legislation doesn't get the same kind of scrutiny. There's no possibility to amend it. There's very little time for debate, and there is a sort of convention that the House of Lords will not oppose it. And so the government made that change. and it came into force immediately in June 2023. And we were obviously concerned for a whole range of reasons. We were concerned about the impact on protest rights because it sort of lowered the threshold for police interference to sort of a level at which they would be able to interfere in almost any protest. I mean, any protest is going to cause some level of disruption. That's the point of them. And then we were also concerned that the government had acted undemocratically. First of all, that it didn't actually have the power to do this, that it had the power to clarify or provide examples of serious disruption, but not to totally change the meaning. And also just that, as I say, it seemed undemocratic, and then potentially unlawful to do something a parliament has kind of clearly said, actually, we're not going to do this, to just for the government to go ahead and do it anyway. So we challenged that in court, and I mean, there was then quite a long convoluted process through the High Court and the Court of Appeal taking in a change of government, but ultimately we were successful.
I mean, when I was reading the Hansard transcripts about the Public Order Bill, the anger in the Lords from all directions, it wasn't Labour or the Lib Dems or the Greens versus the Tories. Like, there were angry Tory peers in that debate as well. And, so you can see why the government were like, right, we've just got to find a way around this. And of course, they didn't have the right to find a way around this, as you proven. But when you had the High Court victory, obviously the government appealed, and then Labour came in and they continued with the appeal. I mean, what was your response when Yvette Cooper was like still going to push forward with appealing this decision?
We were very surprised. I mean, she's on record in Hansard opposing those exact provisions. And it all happened so relatively quickly in that after we won in the High Court in May 2024, the appeal was set for July on the basis that, these powers had been found to be unlawful, but they were continuing to be used by the police to limit protests and to, prosecute people. So we argued very strongly that the appeal needed to happen really quickly because people's rights were at stake. So when the election happened in early July, we immediately wrote to the lawyers for the Home Office and said, your client has changed. Does that mean you have, new instructions on what you'd like to happen in terms of this appeal? And they did come back to us and they said, actually, yes, we would like a bit more time to think about it. So the appeal was postponed. And I think at that point, we were relatively hopeful that they would see sense. They would realize that this was something that they had opposed, a year earlier. And that they wouldn't want to be seen to be defending anti-protest measures introduced by Suella Braverman. But as I say, we were very surprised they came back and said, actually, they did want to continue with the appeal, which was also frustrating in terms of the waste of time. Then wasn't heard until December, and we've only just got the judgment now. So, it has caused almost a year's delay, and almost a year of time where the police have been using these powers. They've been putting limits on protests, and people have been arrested for participating in protests when on an unlawful basis. So that, I think, is really, really concerning.
And do you think there'll be appeals against those arrests now that they've been found to be unlawful, or is that the kind of next steps in people's journey on this?
Yes, I think so. So we now know that the government aren't going to appeal to the Supreme Court. So the case is sort of fully concluded, and the regulations have now been quashed, and that applies retrospectively. So it's as if they'd never been made because they were made without any kind of basis in law to do so. That applies retrospectively right back to June 2023. It's as if they never existed. So yes, anyone who was arrested for a breach of those conditions in the last 2 years does theoretically have a right of appeal. I've been in touch with a few lawyers who acted for individuals who were convicted, and they are planning to appeal. But I think Liberty are also calling on the government to carry out its own review of convictions and prosecutions and even arrests that took place under these powers, because it's clear that those people should have a right of redress.
It's also just such a nonsense, isn't it? Like you say, any protest is going to cause serious disruption. Like in my youthful days as a feminist activist, we caused disruption because, that's what protest is. It's not standing in the corner going, hello, I'm just wanting to say something to you quietly. And, you have to create a disruption in order to get noticed. And it just speaks to this absolute determination to make sure that no protest can really reasonably happen.
Yeah, absolutely. I mean, one of the most concerning parts of the PCSC bill was the noise condition, which meant that the police can take into account how noisy they think the protest is going to be when they're deciding whether or not it can go ahead, and place limits on that. And the whole point of a protest is that it's noisy. You're making your voice heard. It's about your right to freedom of expression. It just, as you say, protests have to be disruptive. Otherwise, nobody is going to pay attention to them. And some of the conditions that we've seen on protests over the last few years, I dealt with one where it was a small union who wanted to strike outside the building that was the headquarters, and the police would actually, no, you have to have your protest like over here, like around the corner. And it's just like, well, this is a protest has to happen at sites of power. It has to happen outside the place when the thing that you're protesting about is happening. There's no point if it's around the corner and nobody can see that it's going on. The point of protest is that it's going to be noisy and it's going to be disruptive. And we have to protect that right.
Yeah, we used to have a samba band leading our Reclaim the Night marches so that everybody knew we were coming and everybody got out of our way and, helped campaign against violence against women. And yeah, now you look back on those days and think, would those protests be possible? But I wanted to go back to something we spoke about earlier, which was the fact that, Just Stop or Extinction Rebellion, Insulate Britain, Black Lives Matter were sort of named as the targets of these bills. But obviously, any kind of protest is under pressure from these new laws. One of the interesting things when I was looking at the Hansard transcripts was Claire Fox, who's not a peer I would normally agree with, saying that if you wanted to protest your low traffic neighbourhood, or you wanted to protest something that might be what we would normally consider to be on the right, as opposed to perhaps more left-wing or liberal movements that are the targets, then you are still going to be criminalised. And she spoke to people who were like, no, this wouldn't affect what we do. This wouldn't affect our protest. It's just about XR. It's just about Black Lives Matter. And how do you think this has kind of impacted sort of left and right narratives about protest and who's allowed to protest and who's, protected?
I mean, I think that's a really complex and difficult question, because we've obviously also seen really violent far-right riots on the streets, which go way beyond what you would want to call a protest, but that also then feeds, but which, and then are appropriately policed. But then that does feed into a narrative, I think, also from the right, that their protests maybe are being policed differently, which is a very sort of difficult question. I think there is definitely a sense amongst the wider public that, these threats to free expression only affect, these quite annoying Just Stop Oil protesters, and actually it doesn't really affect anyone else's right to free expression. And I think we have certainly seen a targeting of some forms of environmental protest. As I say, some of the tactics have been explicitly targeted. And I think environmental protest is policed in a very authoritarian way. But obviously, as we talked about earlier, once you hand the police these powers, they have them and they can use them, and they will use them against other kinds of protest movement, whether that's on the left or the right, or just a kind of cuddly, friendly protest to stop your local library being closed. And again, we've seen that over the last few years. Some of the cases that I've been involved in at Liberty that have had a bit less high profile perhaps than this one. We acted for a man who was arrested during a proclamation event for asking who elected him about the king. We've acted for the campaign group Pregnant Then Screwed, who were trying to organise a march advocating for better childcare provision and maternity leave. And so, these kinds of laws may have been brought in with the intention of targeting direct action environmental campaigners, but they can be used against any kind of protest movement. And I think we should all be worried about handing the police really broad powers that could be used to shut down any kind of protest or demonstration.
Absolutely. And sorry, I think it was probably not helpful for me to frame it as a left-right issue because, as you say, it's, and I would, we need to make sure that we're really clear that the sort of criminal damage and incitement to violence that happened in the summer riots are not the same as the locking on and, the serious disruption laws. They're very different offences. I just have a couple more questions before we say goodbye. The first is, again, thinking a little bit about the government we have now, and what are your sort of concerns about Labour's approach to protest since it won the election last year?
Well, as I said, we were when Labour won the election, I think our kind of priorities around protest were to really argue that they should be looking at some of the laws that have been introduced by the last government and repealing them. Particular concerns around some stop and search powers in the Public Order Act, but really we were calling for a repeal of all of these new powers, and so it was disappointing when they made the decision to continue to fight our case, and an indication that perhaps they were not going to be very positive towards the right to protest. And I think we're seeing that now. So the crime and policing bill is currently going through Parliament, and that contains some provisions which were actually introduced by the last government. So the bill would criminalise wearing a mask at a protest or wearing face covering to protest if the police have designated that protest will be one where that applies. And that has huge consequences for the right to protest, for disabled activists, for activists who are Muslim, perhaps, for activists who maybe are dissidents, who don't want, their identities to be kind of publicised. And I think it's really surprising and shocking that the government brought back this provision that was introduced by the last government. So I would say that it doesn't bode well for protest rights under Labour.
I mean, it's so ridiculous. It's such an example of someone having like, oh, I've got an idea, people are masked up and that's bad, and no one thinking through the many, many consequences or reasons that someone might be. Yeah, maybe someone is masked up to disguise their face in order to be hostile or to, get up to no good. But as like 5 years after the pandemic, I think we're used to face masks. We shouldn't be thinking that is an automatically hostile act. And as you say, there are so many different groups of people who might need to wear a face mask for all sorts of different reasons. Our final question is something we ask all of our podcast guests. As you know, the podcast is called In Solidarity. And so what does solidarity mean to you?
Oh, that's such a good question, and I hadn't thought about it before coming on. I mean, I suppose fundamentally it means like standing shoulder to shoulder with everyone, but particularly with people who are, particularly with, I guess, anyone who is disadvantaged in some way, and kind of thinking about what you can do to express solidarity with marginalized, disadvantaged groups. And like for me, at Liberty as a lawyer, like how to use the kind of power that comes with that profession and with Liberty's kind of institutional weight to advocate for people who, well, actually, no, not to advocate for, but to advocate like with, I think is the really important thing, to advocate with people who are kind of, at the sharp end of state power, and to try and express that solidarity where I can.
Perfect, thank you. And I'd encourage all of our listeners to check out Liberty if you haven't done before, and see all the amazing work. So much of Liberty's work intersects with things we report on here at Open Democracy, from their work on military abuse to the work on anti-protest, facial recognition, surveillance, the rise of AI tech and all of that. So we have so much in common, and it's just really brilliant to have you on the podcast, Katy. Thank you.
Thanks, Sian. It was really nice to chat to you.
In Solidarity is produced by James Battershill, Ayodeji Rotinwa, and Carla Abreu. The theme song is Odyssey by Edward Abela. Please don't forget to subscribe to the show if you've enjoyed today's episode, and to leave us a review on your podcast platform of choice. And if you've really enjoyed it and would like to help support us in our production of these episodes, you can do so at opendemocracy.net/donate. And finally, Open Democracy has a newsletter So if you would like to get the most important stories from around the world delivered direct to your inbox, you can subscribe to that at opendemocracy.net/newsletters. Thank you so much for listening, and as always, have a great day.